एवरीवन, जय हिंद एंड वेलकम टू द प्लेटफॉर्म ऑफ श्रीराम IAS। आप सभी का स्वागत है श्रीराम IAS के प्लेटफॉर्म पर। एंड इन टुडेज सेशन विल बी डिस्कसिंग हिंदू आर्टिकल जो द हिंदू में आपका पब्लिश हुआ था, एंड on that basis we'll be going through the complete anti-rape laws that were formulated in India and what are the current statistics, उसके बारे में भी हम बात करेंगे। And this topic matters for your UPSC. It is very important topic for you UPSC because अगर मैं बात करता हूँ आपका when we talk about the different GS papers, so in GS paper 2 vulnerable sections, legal reforms and governance, the questions related to these are asked. Along with this, the GS1, it deals with society, women issues as well as social change. And in GS4, we have ethics, empathy, justice delivery. So all these things, that is the relevance of to your UPSC. And ultimately, when we talk about India's rape laws, they mirror the society's evolving understanding of the gender, consent as well as the constitutional rights. Now, when we talk about the frequent appearance of such type of questions, you will find it in your mains as well as in your prelims examination that the questions would be asked from such type of topics that will be there. All right, and we will understand how we have complete change of the various laws which were there, and ultimately what was the colonial legacy. Then after the colonial legacy, how the Mathura case or Tukaram versus state of Maharashtra led to an epic turning moment where we have seen that the rape case had been, anti-rape case, they had been made strong and stronger in India. All right, so that is what we'll be studying in today's session and in this video. Now, before moving ahead, let me tell you that if you are encountering with any problem related to your studies for UPSC, what you can do is you can avail this free 1:1 mentorship. अगर आपको कहीं पर भी प्रॉब्लम है, कोई भी दिक्कत है, परेशानी है फॉर योर यूपीएससी प्रिपरेशन, आप इसको यूज कर सकते हैं, फ्री 1:1 mentorship at श्रीराम IAS. इसके लिए आपको बहुत छोटा सा काम करना है, दैट इज यू हैव टू फिल द गूगल फॉर्म दैट्स गिवन इन द डिस्क्रिप्शन बॉक्स. उसको आपको फिल कर देना है एंड आवर ट्रस्टेड मेंटर्स दे विल गेट इन टच विद यू और आपकी जो भी परेशानी है उसको सॉल्व जरूर करेंगे. Now, why is this recent debate and why I am talking about anti-rape laws in India? Because there was an article in the Hindu on 18th November 2025 और यहाँ पर जो continuum of reforms है, कैसे हमारे जो आपका anti-rape laws हैं वो आपका reformed हुए right from the colonial era to the present day was discussed and examined. इसी के साथ साथ when we are talking about the expanding of the definition and harsher punishments have been provided in the रिफॉर्म्ड लॉज. ठीक है, जो आपका रिफॉर्म्ड लॉज है उसमें आपका डेफिनेशंस को एनहांस किया गया, साथ ही साथ आपका जो है हार्शर पनिशमेंट प्रोवाइड की गई. बट एट द सेम टाइम एक कॉन्ट्रडिक्शन आपका देखने को यहां पर मिलता है अकॉर्डिंग टू दिस report, and that is low conviction rates in the case of the anti-rape or the rapes that have been committed. And also along with this, there are certain unresolved issues like marital rape, which is still exempted, and also there are certain implementation gaps that remains vital or the critical, and they are the unresolved issues that we'll be talking about. Now, when we talk about the early IPC or the Indian Penal Code framework, in the pre-independence and even after the independence, right from 1860 to 1980, what was the colonial legacy? So over at this point of time, there was a narrow definition. The narrow definition was used, and only for the rape it was peno-vaginal, or you can say the penile penetration only was actually included in the rape laws. All right, or definition of the rape, and there was also limited consent. It was understood within restrictive moral framework, and as well as there was a marital exemptions that is still there, that is the husband is absolute or he is absolutely have a complete immunity and it was fully protected. All right, at the same time the burden of proof requirements were extremely stringent, and the burden of proof lied with the victim. All right, and not to the accused. At the same time, there was shaming that deeply embedded in the legal culture, and that led to the victim's stigma as well. So these were the early framework that we can see. Later on, there was the Mathura case. The Mathura case in 1972, and the judgment came in 1979. And this is also known as Tukaram versus state of Maharashtra. Tukaram versus state of Maharashtra, or the Mathura case, a very important case for turning the tide in the favor of the anti-rape laws in India. Now, as we are talking about the Mathura case, Mathura was the name of a minor tribal girl, and she was raped in custodial, in the police custody. All right, she was raped in police custody, and ultimately Supreme Court acquitted the accused. There were two accused, and they were acquitted, reason or citing that there was no resistance from the Mathura, from Mathura. All right, and that had, or it had a very severe impact. And there were nationwide women's movement, and later on it led to the amendment of the criminal law. And there was Criminal Law Amendment Act in 1983 that was passed, and also it led to introduction of Section 114A in the Evidence Act, and the presumption of no consent was laid down. As well as it also established custodial rape provisions, and these were the changes that were brought. So in 1983, there was a Criminal Law Amendment Act that was passed, and over here, the custodial rape was actually defined, all right? And it redefined the rape that happens in the custody situations. At the same time, the proof of burden, it partly shifted. Please remember, partly shifted to the accused, not fully shifted, and also it increased the sentences of the offenders and even recognized authority, victim context, and the power dynamics that is there. So over here, even after the reforms, the definition of the rape, it still remained narrow. All right. Now, what happened was that after this, there was, because the rape laws were actually, they were made stringent, so there were enhanced reporting. All right, more survivors, they came forward, and there was increasing reporting that was seen. All right, along with this, in the Gujarat 2002 and the other high-profile cases or the incidents, they sparked protest. Along with this, there was even the fast-track courts which were opened in the various states. However, they were sporadically, they were established across the state, and even when we are talking about the women's group, they pushed for comprehensive reforms and also asked for broader definitions that were demanded by these various women groups that were there. Now, as we talk about the next case that happened, I know that most of you must have remembered this case, and this case is called as or known as the Nirbhaya case in 2012. And what happened over here is there was a brutal rape gang rape that happened in Delhi, and it sparked unprecedented protest all over India. There was a nationwide protest that that happened, and later on that led to the formation of Justice Verma Committee for recommending the comprehensive reforms. And the key reforms that were recommended were that there have to be a gender neutral law when it comes to the rape. Along with this, it also said to criminalize the marital rape. Along with this, the police reforms and accountability should be there, and victim support over the punishment focus was recommended by Justice Verma Committee. Now, when it comes to the Amendment Act, there was an Amendment Act, Criminal Law Amendment Act, that was brought in 2013. In this, it expanded the definition of the rape, and there were all forms of penetration which were included to be called as rape, and there were new offenses which were created. All right, the new offenses that were created were stalking, voyeurism, as well as acid attacks, and the age of consent was set at 18 years of age. Even there was a death penalty that was introduced for the rape causing death or the vegetative state, and even stricter punishments were introduced for the gang rape. All right, no criminalization of the marital rape was done even after the recommendation by Justice Verma Committee in 2013. At the same time, there was a POCSO Act that was passed in 2012, Protection of Children from Sexual Offences Act in 2012, that protected children from any sexual offences. All right, over here, it is a gender neutral act that protects all children regardless of their gender. And also it is over here we have child friendly procedures that have been implemented where trauma sensitive investigation and trial processes have been laid down. And there is a mandatory reporting. All right, the legal obligation to report the child sexual abuses. However, this has been criticized because the the mandatory reporting can harm minors who are in consensual adolescent relationship. However, this provision is there in the POCSO Act, and along with this, there were special courts, dedicated judicial infrastructures that were created all over India, and along with this, there were higher punishment where aggravated assault carries severe penalties as far as it deals with the children and the sexual offences with the children. All right, now there was another amendment, Criminal Law Amendment Act, that was brought in 2018. Now over here, the death penalty had been expanded for rape of girls which are below 12 years, and along with this, the minimum sentence or the minimum punishment had been raised across all categories. Like for example, the minimum punishment for the rape initially was 7 years, but now after this amendment, the minimum punishment is for the 10 years. All right, and it can move up to life imprisonment or even death penalty depending upon the case. At the same time, the deterrence focus was there, but the crime statistics, they question this effectiveness of increasing the increasing or the minimum punishment or the increasing of the different punishments that were implemented. Now, we have different laws which deals with anti-rape. We have IPC provisions and which have been after 2023 replaced by Bharatiya Nyaya Sanhita. All right, we have POCSO Act that lays down protection for the children in the sexual offences. If there are any offences which have been directed against the children, and at the same time we have fast track courts which have been established, and NALSA victim compensation schemes are there for the anti-rape laws, or these are the legal framework that we have, legislative framework that we have, and there are certain procedural safeguards right now that there would be in-camera trial for the sexual offences. Along with this, medical procedures have improved and there is now no two-finger test that would be conducted, and it has been banned completely, and also there is enhanced victim protection mechanism that have been laid down that we can see at right now or in the current legal framework. Now, the issues that were highlighted in the Hindu article was that there are expanded laws. We have definitions which we have broadened for the rape. Also, the punishments have increased and the procedures have reformed when it comes to the anti-rape laws in India. But at the same time, you will see that the conviction rate is quite low. It remains low at about 27 to 33%. The trials, they face massive delays. The survivors drop out of the process because of these delays, and ultimately the police investigation quality is highly uneven. That has been highlighted in the Hindu article. So we have lots of laws which have been formulated, and even the laws which have been reformed by the legislator. But at the same time, the implementation remains a concern when it comes to the anti-rape laws in India. At the same time, when we talk about the marital rape, this remains unresolved. Even after Justice Verma had recommended for it, but still now it has not been criminalized in India, and there are certain narrow exceptions that exist when it comes to the marital rape. All right, when we talk about the debate, there are multiple petitions which have been filed across in different courts, and the Hindu article, it emphasizes this as a major missing link when it comes to the anti-rape laws in India. However, there are two opposing views. We have two different views when it comes to the marital rape, because when we talk about the marital rape and criminalizing it, so it is opposed. It is opposed because of the misuse of this particular marital rape. All right, that could be misused, and ultimately that will lead to, or it will lead to the family sanctity as well. All right, along with this, it has been favored. All right, we have two different set of views. It has been opposed and it has been favored. It has been favored for being or for supporting the bodily autonomy as well as the constitutional rights of that we have. We have Article 21 in our constitution that defines that there would be a right to life and personal liberty. So, right to personal liberty, actually that is the constitutional right, and ultimately it supports the constitutional right. And then if we talk about the constitutional right, marital rape should be there in the anti-rape laws in India. All right, now when we talk about the UPSC, you have to prepare both the sides of this particular issue that we have highlighted right now. All right, you have to prepare both sides with constitutional, social as well as legal arguments when you are preparing for the UPSC. Now there are certain implementation gaps when it comes to the anti-rape laws in India. The first thing is that the infrastructure and trained personnel shortage is there, and that that leads to inadequate forensics in India. Along with this, even we have the fast track courts, but they also face backlogs, and that creates court pendency. We have quality that varies dramatically across state, that leads to poor investigation, and we have victim support services which are inadequate, and that leads to weak protection. At the same time, the examination protocols are not uniformly followed, and that leads to medical inconsistencies, and also the social shame prevents survivors from coming forward. And because of the social shame, the reporting had been underreported. The various cases had been not reported when it comes to the rapes that are there in India. All right, these are the data trends and challenges. You can see the case reported, and these are in 1,000, and also you can see the conviction rate. So over here you can see that there is increased reporting after 2012. All right, after 2012 there had been increased reporting, but at the same time you will find over there that the conviction rate, it stagnates at 27 to 33% only. All right, and there are certain hidden issues that we have underreporting when it comes to marital rape, to the or the rural rapes or the rural scenarios. They are not reported, or caste-based, even they are underreported. Along with this, cyber-enabled violence is rising, and even we have NCRB categories which are evolving, and these are certain hidden issues that we can see in this data itself. Now, when it comes to the debate on the death penalty, all right, there are both the arguments. We have the argument for and even the arguments which are against it. Now, when it comes to the arguments that favors the death penalty, so of course, it is a symbolic deterrent that is there in any law. All right. Along with this, when it comes to the public demand, the public demands for the harsh punishments for the rapes, and also it protects the vulnerable children, and the severity matches crimes brutality as well. At the same time, the death penalty had been, there were arguments that had been against it, because there is no evidence of such deterrence when it comes to rapes in India. At the same time, it may incentivize the killing of the victim so that the evidence could be destroyed, and even shifts the focus from prevention and rehabilitation as well. As well as when we talk about the effects, it disproportionately affects the marginalized as well. And over here, this debate is actually a very good topic for your mains, essays, as well as for your GS2 question that are there. Now, also when it comes to the rape in India, it has a social as well as cultural dimension. All right, when we talk about the media, they sensationalize it and influence the judicial delivery or the justice delivery, and that is why there are certain media trials whenever we have rapes which are committed in India, as well as we have honor and purity obsession, because we have patriarchal society. So the rapes are seen in a case of honor or the purity, and we have the obsessions of such obsession that can be seen in the social and even the cultural dimension in India as well as when it comes to the family. The family pressurizes the victim, and that leads to the forced compromise settlements. And even when it comes to the marginalized section of the society, the Dalit, the Adivasi, the women face higher systemic biasedness when it comes to these marginalized section. At the same time, when we talk about the access, there are access barriers as well. There is poor access to the legal system, legal aid and resources, especially when we have the illiteracy of the women higher as compared to the male literacy. So ultimately, these are certain social and cultural barriers and the dimensions that you will see. Now, what are the different institutional reforms that are needed to tackle the rapes in India? The first and the foremost is that the police reforms. The Verma Committee recommendation, they are still not yet fully implemented. So there has to be police reform, sensitization of the police, as well as when it comes to the kits, we have to have standardized kits, trained personnel, timely testing, and the forensic infrastructure has to be, it has to upgrade itself. At the same time, when it comes to the medical staff, they have to be trained in gender-sensitive and trauma-informed protocols as well. At the same time, when it comes to the witness protection, robust mechanism have to be there so that it can prevent the intimidation, and even for the victim support system, counseling, shelters, legal aid and rehabilitation should be there, and it should be there legally. Alright, along with this, accountability mechanism should be there for the investigation and even for the trial lapses. These are certain institutional reforms that are needed for the anti-rape laws in India. Now, at the same time, when we talk about the framework that has to be created for these different, the rape cases which are there, we have to move towards a survivor-centric framework. All right, we have to move towards a survivor-centric framework. We have to have a humane approach apart from the punitive approach that we have. All right, there have to be a consent education where comprehensive sexuality education should be there in the schools. Along with this, community awareness where grassroots programs should be arranged, and they should challenge, or they must challenge the patriarchal norms, and this must be, this must be made clear that these are actually the challenges that we are facing in the society. And also we should have sensitivity training and standardized protocol when it comes to the policing. And along with this, the gender sensitivity training should be there for judiciary and legal professional, even the medical staff. And from investigation to trial to rehabilitation, there must be dignity at every stage. All right. So that would be all. That is all that I have to, lay down on this particular topic, the anti-rape laws that have been formulated in India, or they are right now in India. And again, I'm telling you that this is a very important topic for your UPSC. So do not miss this video, and also share this video with your friends who are preparing for the civil services, as well as do not forget to like and subscribe to our channel. Thank you. Bye-bye. Take care and Jai Hind.